All right, thanks so much for being with us here on Atlanta News First Plus. I'm Joy Lim Nakrin here with attorney Jamara Edward Shipp. Thank you so much for being with us,
Thank you
Mr.
for having
Shipp. The reason Mr. Shipp, is joining us here again today because he loves our company, number one.
Of course, of course.
But number two, we're following some breaking news, a really major development in the YSL case. The trial is now on pause at the moment. Apologize, I did not mean to. I'm struggling with trying to get that
Mr.
video
Nichols,
up, but here's the
Mr.
video.
Garner, good morning.
So the YSL trial
And Mr.
is
Ryan and Misty
on
Williams, good
pause.
All right, counsels for the state.
And this
Ms. Lowe,
comes
Ms. Hilton,
after one of the
and Mr.
defendants
Smith, good
was
morning.
stabbed on Sunday night. Remember, we reported to you that one of the defendants, Shannon Stillwell, had been stabbed inside the Fulton County Jail on Sunday night and is being treated.
And we'll update them accordingly and recess
And
them and wish them
What
happy
we've
holidays.
learned
So,
is that
okay.
because of that, remember, we told you that court was dismissed early yesterday, and the jurors were told to come back today. And it was still kind of a question mark whether court was going to resume as usual. But again, with that individual being stabbed, Shannon Stillwell, the decision was made by Judge Glanville to put the trial on pause until January 2nd. So that's about 3 weeks. Should note that a suspect, Willie Brown, has been identified as the person who stabbed Stillwell after a fight broke out, and that individual, Brown, is now facing additional charges tied to what happened, in addition to what he was being held for as well. But Judge Glanville dismissed the jury just about 2.5 hours ago. First thing, Mr. Shipp, what's your reaction?
First reaction is, why weren't these guys separated from the general population? Fulton County has their own issues with inmate stabbings, inmate deaths. So to have these guys in general population with other inmates, it just begs the question of why. We know that this is a high-profile trial. We know that these are high-profile defendants. So again, why weren't these guys separated out and kind of held elsewhere so that we don't have situations like this? Of course, one could argue that one could be accosted or stabbed in any facility. However, when you are dealing with a facility like Rice Street, Fulton County Jail, that has a history, that has a DOJ investigation into all of the going-ons at this particular jail, it just begs the question of, why did it have to get to this point?
Yeah, absolutely right. I just want to share with our audience what Judge Glanville told the jurors earlier today. Let's listen.
Remember yesterday we recessed because one of our participants has had a medical issue, and I was telling you about that. Well, unfortunately, that medical condition still exists, and given the length of time that we're going to have to probably address that, it might be just more prudent to recess you and give you an early recess instead of recessing you this Friday.
All right, so essentially he says we're going to recess you instead of giving you an early recess this Friday. And so just to reiterate, the jury doesn't know. They were just told that it was, we assume they don't know. They were just told by Judge Glanville it was some kind of medical issue, and that was to avoid prejudicing the jury in some way. Do you think that there's a risk that they could find out now that they're going to be, on break for 3 weeks?
Yes, we live in a very interconnected world. I mean, we're streaming right now, live on the internet. That can be accessed by somebody's cell phone. So again, there is a high risk that these individuals will find out what exactly happened. I think we as lawyers, we tend to try and see the bright in some aspects and hope that the jury would not be tainted with outside information. However, to be quite realistic, at risk of sounding cynical, I do believe that these jurors will find out about it. And there may have to be a curative instruction that if there was any information given to them about what happened to Mr. Stillwell, that they disregard that information and don't use it to determine whether or not he is innocent or guilty.
Yeah, absolutely. Any final thoughts on this YSL case?
Again, this just shows the logistics of having 28 defendants over 18 months of just jury selection, getting into trial. It just shows, these RICO cases are not something that should be taken lightly and perhaps should not be prosecuted by different offices so easily.
That is definitely a criticism we have heard before, that is for sure. Okay, I also want to ask you about another high-profile case that we are following, and this is the case against Hannah Payne, who is on trial for murder, and she actually took the stand in her own defense yesterday. Again, she's accused of killing a 62-year-old black male driver who allegedly, the accusation was, left the scene of an accident, and she's accused of essentially, ignoring orders by a dispatcher to not chase him down. And after we heard her testimony yesterday, we actually heard from a rebuttal witness by the state in court today, which was a little bit of a surprise to many individuals. Here's a video of Hannah Payne testifying. She's 25 years old. The incident happened in 2019. That's the victim, Kenneth Herring. And Payne says she had followed Herring, was on the phone with police, hoped to be a, quote, messenger. Well, today prosecutors pulled up some interrogation video that happened 2 hours after the shooting. She testified that when she walked up to Herring's truck, he was the aggressor. That's what she claims. Pulled her into his truck is what she says. And during a tussle, Herring pulled the trigger is what she is claiming. Well, today the state took an opportunity to bring former Clayton County Police Detective Keon Hayward to try to debunk what Payne said. Let's listen to that.
When you hear the defendant in the interview saying that she was telling Mr. Herring to stay in the car, did you hear her say that?
Yes.
Were you aware that on the 911 calls, she's saying the opposite, get out of the car?
Not at that time.
Yeah, and so the defense rested yesterday, like I said, after Hannah Payne had given her testimony. Closing arguments expected really at any moment. And we actually have, I want to show you guys this live look inside the courtroom, but we're just showing the seal right now because it appears to be lunch recess inside the Clayton County courtroom. But, when court resumes, we're going to take you there as well. But I want to ask you, Jamara, what you think of this rebuttal testimony and, how it plays off of what we heard from Hannah Payne. Overall, how do you think this case is going to go? When it gets to the jury, what do you think that the state has met their burden?
I believe that the state has met their burden, and that's coming from a criminal defense attorney. But for Hannah Payne being entitled enough to feel that she had adequate training to accost an individual for a misdemeanor, this would have never happened. And I think that the state has hammered that in, that she was the aggressor in everything. Mr. Herring was not found with a gun. He was not found with any weapon. He was a guy who was going through a medical episode. And even if he did reach out to grab Hannah Payne, how are they going to say that he wasn't grabbing her for help, as almost in a way to say, help me? It speaks to the volumes of entitlement that certain individuals have when it comes to things of this nature, and it's a tragic situation. Mm-hmm. This is a young lady who, if she would have just went about her business, she may very well have become a productive member of society, but now she's facing murder charges because she felt entitled enough to accost an individual because she felt, without any prior investigation, training, knowledge, anything of that nature, that this guy had committed a misdemeanor crime, when misdemeanors are punishable by the maximum of $1,000 fine and 12 months in jail.
Mm-hmm.
So
at the maximum.
At the maximum. So again, I hate to see how it's playing out for the defense because I am a defense attorney, but again, I do believe that the state has met their burden, and it's going to be up to the jury to determine whether or not they want to find her guilty.
Yeah, and clearly a very racially charged case, and the jury makeup there in Clayton County, presumably would be a diverse jury pool, and it'll be interesting to see, which way they go. What is your prediction?
It depends on what type of jury was picked. I don't have the information in front of me to determine what the makeup of the jury is, but if it is a diverse jury, we would be deluding ourselves if we said that some of these individuals who might be minorities would not think of times that they have been accosted by individuals who felt that they were entitled to police them without any formal training. So again, it just shows that sometimes the entitlement doesn't work out as those who think that they have it think that it will.
That's right. Absolutely. Really appreciate it. We're going to be keeping our eyes on that Clayton County courtroom as, we expect the closing arguments, and then, of course, it would be in the hands of a jury. Shortly after that, they're going to get their jury instructions and so forth. In the meantime, we have other major cases, of course, that we are following here in the state of Georgia, including in Fulton County, including regarding our former president, Donald Trump. And here's something that could impact what happens here in Georgia. We'll see. 9 members of the Supreme Court could decide the fate of the former president, Donald Trump. The U.S. Supreme Court received an emergency request that could impact his Fulton County case, potentially. First, let's go to this story by my colleague, Doug Reardon, with a bit of the background.
Special counsel Jack Smith wants the Supreme Court, not an appellate court, to decide whether Donald Trump can invoke immunity on charges he faces in the nation's capital and elsewhere, like in Fulton County. Trump's attorneys have already noted their intent to use presidential immunity as a defense against racketeering charges in Georgia, and a Supreme Court decision in their favor would be a huge advantage. But a ruling in favor of Smith could be devastating for Trump's defense in Fulton County, taking immunity off the table. During the Watergate scandal, the Supreme Court ruled that then-President Richard Nixon couldn't use presidential immunity to prevent turning over secret tapes that acted as key evidence in the scandal's investigation. It's the closest thing we have to precedent on this. Doug Reardon, Atlanta News First.